The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Good afternoon. I'm Anna Hobson, the Marketing Manager at the American Chamber of Commerce Resources, as well as HR Simple. We would like to welcome you all to today's webinar, I-9 Compliance. Today's webinar will be about 60 minutes long, and at the end, we will provide SHRM and HRCI codes. Those will be put up on the screen for you. If you do have any questions, there's a question area in the chat box. We'll be answering questions during the end of each section, and I'll be able to read your questions off to David. If you need to go over the webinar again, it will be posted to our YouTube page, which is under the name HR Simple. Our presenter today is David Jones from Fisher Phillips. Fisher Phillips writes our Workplace Safety and Health Compliance Manual, which is available on our site, hrsimple.com. So feel free to go ahead and check that out on our products page. David is the managing partner of the Fisher Phillips Memphis office, and he practices exclusively in the area of immigration and related employment and compliance matters. He is listed as a Mid-South super lawyer and nominated by Memphis Business Journal for the 2018 Best of the Bar Awards. Before I pass this over to David, I just wanted to thank everyone for coming out and learning with us today. So on that note, here's our webinar on I-9 compliance.
Thank you, Anna.
Sure. Passing this over to you right now.
All right. And okay. Well, good morning or afternoon, everyone, depending on where you are, I suppose. Thank you for participating in today's program. As Anna mentioned, we're going to be talking about ICE and I-9 enforcement. We'll also be talking about some related issues that come up in the process of that. As she mentioned, I am happy to take questions. I'll be pausing periodically, specifically between certain sections, to have an opportunity to respond to those. And I imagine we would have some time at the end as well to go over any questions that you might have. So please feel free to ask those. So as you've probably noticed just by watching the news or based on what you see in your own businesses, we are seeing record-breaking worksite immigration enforcement. Under the Trump administration, they have taken an extreme emphasis on trying to pick up undocumented workers, remove undocumented workers, and to penalize employers for employing undocumented workers. In past years, the focus had been more on getting the employees or the undocumented workers out of the country. Then it shifted more towards penalizing the employer. And now we're looking at both sides of that moving forward pretty significantly. The arrest of undocumented immigrants more than doubled over in 2017 over than what it had been. And then in 2018, it was 11% higher than 2017, coming in at almost 160,000. There was a major raid across the country, 98 7-Eleven stores in 17 states from California to Florida. There were 21 arrests in that, and this is significant for a lot of people because 9 of the individuals arrested were the owners of the 7-Eleven franchisees. So it shows that there is a significant potential for penalties for employers who are knowingly or recklessly violating our immigration laws. We've seen record-breaking raids at gardening businesses, meat packing plants. Each raid breaks the record of the last raid, as it seems. And the most recent major raid picked up 146 workers from a meat packing plant in Tennessee. And overall, worksite enforcement actions have just quadrupled. And we'll talk about what worksite enforcement actions really mean in that context. But at this point, we really state it's not a question so much as if you will have an I-9 inspection or an ICE visit. It's how to be ready for when you have one of those. And so that's what we'll be talking about today, what to do when they show up and what to do beyond that. So when ICE shows up, they will sometimes have a search warrant. There is no notice requirement for ICE to show up with a search warrant. They do have two types of search warrants we'll get into more detail on in a moment, judicial or administrative. You're not allowed to interfere with a search. You should comply with the terms of the warrant as specifically stated in the warrant. You don't have to do anything beyond that, and you cannot resist. So the way we approach this is simply to verify what's in the warrant and allow the ICE officers to just move forward with those particular steps. Depending on who is the first contact for the ICE search, that individual should contact management and legal counsel immediately to make sure that everyone is aware of what's going on and to protect their rights. And it's very important to keep track of what is seized or taken. You actually can even videotape what the ICE officers are doing that's lawful. So in the world of cell phone video, that's something that is very helpful to make sure there's a complete record of everything that went on. The two types of search warrants that we mentioned were the judicial and administrative. And judicial warrants are what you typically think of as a regular warrant by a government office or officer, police, or what have you. These are actually taken to a judge, they're reviewed by a judge, and they're signed off on by a judge. So these will allow ICE officers to come in and take specific steps, go into certain areas of your business, talk to certain individuals, take certain individuals, take certain items. Those warrants have a lot of power, and you have to be very attentive to what they state. On the other hand, the more common warrant that we actually see is something called an administrative warrant. And this really has no legal authority. This is basically a document produced by DHS telling DHS officers who the person is that needs to be taken into custody, why that person needs to be taken into custody. It's somewhat of a charging document. It has no legal effect on a company or workplace in terms of letting ICE do anything besides come into public areas. So one of the key distinctions is without the search warrant, ICE cannot go anywhere that would be considered private. But a lot of businesses have what we consider public spaces. So an easy example would be a restaurant. In the dining area is all public area. ICE is allowed to come in. They're allowed to talk to individuals who are there. And if they encounter someone who is to be arrested, they actually can arrest that individual. They can't go back in the kitchen. They can't go back in the offices. So if you have a business where it's not entirely clear what is a public area and what is a private area, it can be helpful to delineate those very carefully to make that clear. As a practical matter, what we've seen by ICE in the last several months or in general is they've been getting people in parking lots. So rather than even going into the place of business, they will simply wait outside for workers who are on the ICE warrant to show up, and they'll take them in custody in the parking lot. So it's usually if ICE is going to be coming in to your workplace, they're either serving a specific document, such as a notice of inspection, or they would have a judicial warrant. So the notice of inspection is really what we see most as employers. This has to do with Form I-9, which everyone knows and loves. Basically, ICE goes around to employers. They may do it randomly, they may do it targeted, they may do it because they had workers that they arrested in your parking lot. What they're doing in this process is verifying that you have properly complied with the I-9 rules. They give you 3 days by law to provide what they're requesting, and they actually, for whatever reason, tell you you can waive the 3 days. I don't know anybody who would ever want to waive those 3 days. I certainly don't recommend it. And in fact, we're usually able to get up to a week or more of an extension when necessary. So it's always helpful if a manager is out or there's some other issue along that line that we can point to ask for more time. ICE um, will usually accept that. The I-9s can be provided as originals, microfilm, microfiche, or electronic. I've always found it amusing that they still use the terms microfilm and microfiche for I-9s. I can't imagine anyone ever having it like that. I've certainly never seen it, but according to the law, that's still an acceptable way to do it. They may come back to your office or your business to review those I-9s once they are ready. They may ask you to bring them in person to the ICE offices. Very frequently, they will just ask you to send them over. And they have been allowing us to deliver them through secure FTP sites as of late. So that's usually the easiest way we can get those over to ICE, and then they will look at those that way, and also that prevents us from sending any original documents anywhere or losing everything. And plus, everyone has a complete digital record of what ICE has. And so there is no subpoena or warrant or anything along those lines required for an ICE inspection, I-9 inspection. You basically consent to that in the process of completing an I-9. And so that is going to be a normal part of your daily business activities that you have to deal with these days. When you provide everything to ICE, you may have to give originals. I mentioned they have been letting us do FTP sites as well, but sometimes for whatever reason they may want us to insist on originals, and they may insist on actually inspecting the I-9s in the presence of a company representative. They will sometimes, if it's a smaller business or if they have some serious concerns about what's going on, then they may take that opportunity to actually look at the I-9 forms on site. It's pretty rare, particularly because of the backlogs that they have. We have some I-9 audits that have been pending for a couple of years, and so we haven't even heard back from ICE on those. Depending on the office and the importance of that particular investigation, they may move on it more quickly. But because of the backlog, we're typically just going to be providing copies and often electronically. So what we are actually providing in that process are the I-9 forms for current employees hired after November 6, 1986. That is the date that the Immigration Reform and Control Act took effect and the I-9 became required. If you have an employee who was hired before November 6, 1986, you do not have to have an I-9, and in fact, you shouldn't have an I-9 for that individual. They may ask for I-9 forms for terminated employees within the required retention period. So we'll touch on this again, but the retention period is 1 year after termination of the employee or 3 years after hire, whichever is later. They will request an electronic employee listing. That's basically for their benefit to see who all of your employees are and make sure they have I-9s that correspond to that. And to support that information, they will also ask for quarterly wage and hour reports and your payroll data. They're looking to see who was paid during these periods and make sure that those individuals also appear on your report. And they're pretty detailed at looking at that information. They also will ask for SSA mismatch correspondence. And I'm going to actually digress for just a moment to kind of talk about that. It's a little bit separate from our program today, but it's becoming a very hot topic with Social Security and the new way that they are issuing these no match letters. And so it also warrants a little bit of history of that process. Social Security has always issued no match letters. They've stopped at a few points in time for reasons we'll discuss, but they've always been there. They exist for one reason and one reason only, to match up dollars to numbers. They are not trying to penalize anybody. They're not trying to arrest anyone. They just want to make sure that the numbers of the accounts match everything and the dollars are going to the right place. Back in the Bush administration, DHS tried to co-opt that process and impose on employers an obligation to take certain steps. And if they did not take those steps, or if the employee did not cooperate with those steps, it would be a reason for termination. There were a lot of challenges to this. Social Security stopped issuing the letters. The policy was eventually rescinded, and then things kind of went back to normal for a while. Now, under the Trump administration, we're seeing a new surge in Social Security mismatch correspondence, and the way they are doing it is now different. They're sending out a simple notice to employers indicating how they should go online and fill out information or to get the list of mismatches, and then they're supposed to respond back to Social Security within 60 days. This has generated a lot of concern and confusion among employers about exactly what they should and should not be doing. The letters from Social Security specifically state that this is not grounds for taking negative action against an employee. You cannot terminate someone solely because they have a Social Security mismatch. Therefore, you become in a little bit of a catch-22 if you have a Social Security no match or mismatch. You tell the employee, and the employee says, okay, and then nothing ever happens. There's really nothing that you can do to that employee based solely on the Social Security mismatch letter, and Social Security isn't going to take any negative action currently because of that. Employers basically at this point just have to use their best good faith and take every situation as it comes. There will be some employees who will come in and say, I'm not lawful, and then of course that would require termination. Others may have some issue they're trying to resolve and just notify you of that, and some may have a new Social Security number. Of course, it's often also just an issue with an actual typo, or sometimes, particularly with people of Hispanic heritage who have two last names. A lot of times in the SSA, DHS, and state records, those names are one's dropped off and the other one's dropped off in a different record, sometimes the reverse. So that's a very common cause of that. So we think it's possible that DHS could try to tag on to this no match process again in the future, and we will have to just deal with that if and when it happens. But for now, employers are kind of have their hands tied. They just need to act in good faith in terms of notifying the employees and responding to Social Security. The reason ICE wants those absent this policy I was discussing is a no match letter can be a red flag. By itself, it's not a red flag, but if you have it with other issues with an employee, that may be a red flag that perhaps the individual is not authorized to be employed. Similarly, they ask for your E-Verify records and any SNVS records, which is the Social Security number verification system. That is used for payroll reporting only. It's not used for employment verification, but you are allowed, not required, to use this system to make sure that the Social Security numbers you're using to report wages are accurate. And so if you were to get a response from that saying it's not accurate, that is similar to an SSA no match letter at that point. They also want business information, employer ID number, owner's Social Security number, address, business license, etc. They're looking to make sure they have the correct information about the business. They're also looking potentially to see if there are other businesses that are related for the possibility of perhaps the investigation moving beyond that. So sometime after the ICE inspection, again, there are severe backlogs with this process right now. ICE will issue a notice of inspection result. Hopefully they would come back and say there are no issues. That's not very common. Most of the time they're initially going to come back first with a notice of technical or procedural failures. And so the best way to think of technical or procedural failures would be forgetting to put someone's title or forgetting to put someone's address. Those are errors on your I-9, but they're not really substantive in the context that they don't affect the fact that you actually verified the individual's work authorization in a timely manner. You just didn't put a title on a document, for example. So ICE gives you the opportunity to correct those. And if you correct all of those errors satisfactorily, they will not fine you for them. Substantive errors, which go to the heart of the verification process, such as not doing the verification timely, not doing the verification, not looking at the correct documents, not looking at the documents in person, not signing, those sorts of errors are considered substantive and cannot be corrected. They can be, I shouldn't say they cannot be corrected. They can be corrected by going in and doing those edits and marking everything that is a correction, and they're going to want you to do that, but it's still going to be count as an error for the purposes of fines. Once you have responded to the technical errors, then depending on how the I-9s are, there may be a notice of intent to fine. And at that point, we would typically enter into negotiations over that fine. You also may get a notice of suspect documents, and that is where there are documents in your I-9s or perhaps just information about the individuals in your I-9s that ICE cannot verify as accurate, or in fact, they know they're not accurate. And they give you an opportunity to provide new documents for those individuals. If those individuals are able to provide new documentation that's acceptable, then everything's fine. If they're not, then that does require termination. ICE will also give notices about, we'll call them discrepancies, but that really refers to situations where they want to talk to employees to verify some information about what's been provided. And this is really code for document fraud or basically identity theft. So if you have someone who has taken another person's identity or social security number for employment, they will typically try to go after those individuals. If there were problems, but the government doesn't think they're sufficient enough to warrant a fine, they can give you just a warning notice, and that's always hopefully what we get. But again, more often than not, there's some level of fine, and we're able to negotiate that, or if we cannot negotiate it, we actually can request a hearing to the administrative courts to go over that. We typically keep them in the negotiation stages, and we often have negotiations that go on for over a year or two. It can be, it's not common, I would say, for that to happen, but it can be, and sometimes that's to the employer's benefit. But typically, unless there's something really egregious, we are able to get the fines reduced. So before I go into what those fines and penalties actually are, I want to check. So Anna, do we have any questions thus far?
We do have one question.
Okay.
In the case of a rehire, who completes a new Form I-9? Which hire date is used to determine the retention period? The original hire date from the first Form I-9 or the second hire date from the second I-9?
Okay, so there's actually a number of different ways that a rehire can be done, and there's certain rules regarding a rehire. So for example, it has to be within 3 years of the initial hire date, and it also has to meet certain standards regarding the I-9 forms. So if you had an older form that's no longer valid at the time of a rehire, you actually would use a new I-9 form. So as a practical matter, we typically look at a new I-9 as being a better practice. But when you do have a rehire, ICE is going to be looking at the original date of hire as well as the termination date, depending on what those are. The rehire process, particularly if a person's been verified as a U.S. citizen or permanent resident, someone whose work authorization is not going to end, there's really not a whole lot to rehiring someone except stating that they have in fact been rehired. If the individual has work authorization, then that becomes a little bit more complicated, because in addition to doing the rehiring, you're also doing what's called re-verification. And you can do re-verification even if you don't have a rehire situation for someone who has work permission that's expiring. So in those situations, you'll also, if you're familiar with the form, you only have one area for a rehire or re-verification. So if you have a subsequent re-verification, you have to partially complete a new I-9, the information at the top of the page for the employee's name and so forth, and then complete the re-verification section as well. So it can be really, you can end up having to add a lot of new I-9s to your file. But I typically, at least for the rehire, we recommend a new I-9 for another important reason, is that if you do a new I-9, you treat it as a new hire, you can get rid of the old I-9, well, at least for the purposes of the normal retention period, because that I-9 may have had issues. It may have problems. There may be something that would cause a fine. But if you have a new I-9 in place, it would mitigate any of those errors, of course, assuming that it was done correctly. Okay.
That's all we have for now.
Thank you.
Sure.
So the most common type of penalty we're looking at with ICE investigations is monetary. And for many, many years, those fines didn't change. It was $110 per violation up to a maximum of $1,100. In January of 2017, they basically doubled that for any violations that occurred after November 2nd, 2015. So substantive or uncorrected technical violations now can range from $220 per violation up to $2,191. And then the knowing hire or continuing to employ violation. So to explain what that means, if you're deemed to have known someone was undocumented when you hired them, or you continued to employ that person after you know or deemed to know that they're undocumented, that's considered a knowing hire violation. And you can see that those range from almost 600 to over 4,000 for a first violation. And when you get into second and subsequent violations, it can be over $20,000 per violation. Those are obviously very serious. And so that is why they're fined at such a higher rate. I'm going to bring up a couple of charts just kind of you can see how these are done. They don't really fine the I-9s by violation per form, so they don't typically state that this form has 2 violations, therefore it's $440. They look at the total number of I-9s and the total number of violations, and then they decide what the fine is going to be based on the percentage of violation. So if you have 30% violation rate, then you're going to be charged $1,200 for each violation. And that's how they work those out. And obviously it goes up with the second and subsequent offenses. Similarly, with the knowing hire, they have the same process. They look at the total number of violations and look at those percentages. In addition to just looking at the percentages, ICE determines a lot of factors in deciding whether or not the penalty should go up, should go down, should be canceled out. One of the key mantras that we have in I-9 compliance is good faith. Whenever an employer can show that they're acting in good faith, it goes a long way to addressing the fine situation, and whether or not the violations involve unauthorized workers is also a very big point. I'll give 2 examples of where those 2 issues have come up both for and against an employer. A number of years ago, we had an employer who had terrible I-9s, very large number of terrible I-9s, but they had tried at least 3 or 4 times on their own to self-audit, to correct them, but they just couldn't get it right. They also didn't have any unauthorized workers. So despite a significant number of errors, ICE actually chose not to fine that company at all. By contrast, we had a company who had an error that is arguably not an error. It related to electronic signatures, and there's some debate about whether or not it should be an error, and ICE has not used it as an error against other companies. But because they had a lot of unauthorized workers, ICE gave them the highest fine possible. And so the unauthorized worker aspect of it is fairly important. The seriousness of the violation as well. Again, if you forget to put someone's title, it's not particularly important. If you don't verify the actual documents or don't get a signature from the employee, that's fairly serious. Business size, obviously a larger business can afford a fine, typically. Sometimes a lot of small businesses, which are where we usually see the worst I-9 compliance rate, are very small, and the fines would actually put those businesses out of business. And so when we have factors like that, we are able to use those as a way to say we should have a reduced fine. Things like being a small business administration loans or having minority status and those sorts of things are all helpful in that regard. And of course, I look at the history of previous violations. If you've had prior violations, they're going to be a lot less lenient on you. If you've never had a violation before, then you're in a lot better situation. The criminal penalties, which have always been there, are the ones that are being used more now and had not been. So that's where a lot of companies are getting concerned and scared, or individuals as well. So it doesn't really seem like to most people that you're harboring, smuggling, concealing, or transporting undocumented workers when you're employing them. But it's very easy to get there. So we'll just do a couple of examples. If you provide housing to undocumented workers, you're harboring and concealing them. If you transport them to work sites, you're transporting undocumented aliens. If you pay them under the table, that's money laundering. It can be mail fraud when you file your taxes. It can be conspiracy. These are all types of violations that are available to the government when there are criminal level issues with the I-9 process. Those 7-Eleven employer situations had this type of issue. The government will also typically, if you're paying people under the table, they'll usually get the IRS involved as well because of the tax issues. That's considered money laundering. And being from Memphis, I always like to talk about mail fraud. So when you mail a report off to the government, I should explain that. It's from the movie The Firm, but anyway. But when you mail a document off, in this case to the government that has incorrect information regarding your payroll, that's also mail fraud. So there's a lot of creative ways that the government could go after employers as a criminal charge that most employers would never expect. Of course, if you are acting in good faith, you're not being reckless and you're not being criminal, these shouldn't be things that you're facing. But if you're very reckless in how you do your I-9 process, it can get to this level. And I used the term earlier, if you were deemed to know that someone was undocumented when you hired or continued to employ them, there's this concept called constructive knowledge. Constructive knowledge basically means that even though you may not have actually known, for the purposes of the law, you did know because of your actions. And the examples of that would include hiring employees without completing an I-9. So if you hire 10 people and you didn't do their I-9, and it turns out that all 10 of those individuals were undocumented, you were deemed to have hired intentionally undocumented workers. The same if you don't actually examine their I-9 documents. So maybe you complete the I-9, but you don't look at the documents to verify their validity. That is also going to be constructive knowledge. Accepting blatantly fraudulent documents, that's a little bit of a tougher one. We're going to talk about document standards in a little bit, but if something is clearly not legitimate and you take it, that's going to be an issue. And if you were to hire someone that could not provide documentation for an I-9 through a temp agency, that's also going to be constructive knowledge. And this is actually bears a little bit more, it's worth a little bit more discussion, because this is something we see quite often, is where an employer will say, I'm sorry, I can't hire you, you don't have documentation, but maybe I can hire you as a contractor, or maybe you can come back through that temp agency. Well, whether or not the person would qualify as a contractor aside, which typically they would not, when you know an individual is not documented or not authorized to be employed, it doesn't matter if you're the direct employer or not. You're not allowed to contract with that individual for employment. So whether it be through a staffing agency or through the process of independent contractor, those are going to be considered I-9 violations. And in fact, they're going to be considered very serious I-9 violations, because those show an intent to get around the system. And ICE takes those very, very seriously. Now, there's other easy ways you can creep up to constructive knowledge. I talked about a little bit about the Social Security no-match letters being one factor, but there are a lot of red flags that exist with respect to potentially being deemed to have constructive knowledge. For example, if an employee says that he or she needs help getting papers, you receive information from IRS, for example, that you reported taxes on someone's Social Security number who said they never worked for you, requesting to sign some documents for immigration, one employee telling you another employee is using fake documents. That one's always a little sensitive, because anyone in a workplace knows that employees will say a lot of different things that aren't necessarily true. However, if that is in conjunction with other factors, it can be a red flag for constructive knowledge. And then employees called by a name that does not appear to be a nickname. So for example, on the paperwork that I do, everything for my taxes and my W-4, my everything, I'm David Jones, but people are calling me Bob on the work site. That's not typically an associated nickname. And so that can be an indication that the person is using a false name for employment. And there are also practices that can be, done by employers that can get that way as well. So if you don't really have good record keeping, sometimes individuals show up with the same information, same Social Security number, same immigration numbers, things along those lines. When people are showing up with the same numbers like that, that also can be a red flag. And in fact, when people are showing up with the same numbers, it often is a sign that they're all getting their documentation from the same place, and it's often also an indication that there's somebody within the company that's assisting them. So look out for things like that. It can be, those can rise to serious issues very quickly. So we're coming to the end of another section. So Anna, do we have any questions regarding that so far?
We do have 2 questions.
Okay.
Our first question is, would seasonal employees have the same process as explained for new hires? If not, how do you go about handling I-9s with seasonal employees?
Okay, so the real question there is whether or not they are in fact seasonal. Seasonal employees are considered employees who have a job indefinitely, but during certain periods of the year, they're not employed. If you look at agricultural, for example, you may have workers who work for you 9 months of the year, every year. If that is the case, they are seasonal workers and a new I-9 is not required. If there is no expectation of continued employment, it just happens that maybe you're rehiring some of the same individuals for the next season, that's not seasonal employment, and that would be a hire or rehire situation.
Okay, and our second question is, if the I-9 is expired and the employee is still with the company, do you have to fill out a new form?
So this is actually, this question actually has a few different variations I'd like to mention. So the key about the validity of an I-9 is at the time of hire. or rehire or those sorts of things. So we're looking at the hire date. The I-9 is valid when you're hiring someone or rehiring someone. Then there's no issue if that I-9 becomes invalid later. It's all about the time that you completed the I-9. Now, if you go back farther in time, they were a lot more loose with expired I-9s. And so what typically happens if you complete an I-9 verification on an expired I-9, particularly if it's an older hire, ICE won't really penalize you for that or require you to redo it. They will typically just have you make a note to the file that you know you made a mistake and you won't do it again. But as of 2000, I want to say 2007 or 9, I can't remember, in 2009, I believe, it was no longer possible also to accept expired documents. So before then, if someone came with a driver's license that expired, you could accept it. But after 2009, the driver's license or whatever identity document must be valid also at the time of hire. And if those documents later expire, that's also not a basis for doing a new I-9 or any kind of re-verification. We see that a lot. We do see a lot of companies now re-verifying expired driver's license, or more common is re-verifying expired green cards. If the green card is valid at the time of hire, you don't do anything. It's just like a U.S. passport. If a U.S. passport expires, I'm still a U.S. citizen. If my green card expires, I'm still a green card holder. I just need to get a new card. So, the expiration dates are really only relevant at the time of hire, except for the situation when someone has temporary work authorization, and then those obviously have to be re-verified, and we'll talk a little bit more about that as well. So, Anna, was that all of those questions?
Yes, thanks, David.
Okay. So what we've been talking about up to now is all the ways you can get in trouble with DHS and ICE regarding your I-9 practices and your hiring practices. Well, when I-9 audits started getting really, really common, employers, back in 2009 through 12, employers started getting really aggressive in their I-9 practices and started maybe going overboard in terms of documentation, re-verification, really scrutinizing their employees. So there actually is another side to this coin, and that's the Department of Justice. So I-9 practices can be deemed discrimination if they're not done properly, and the Department of Justice is who enforces immigration-related discrimination. So again, I-9 violations. So if you are treating someone different for the completion of an I-9 in terms of their documentation that you're requiring, their national origin, their immigration status, any of those things, if you're using E-Verify differently, all of those things can rise to a level of discrimination, and then you'll get a call from the Department of Justice. These are less common because the Department of Justice isn't going out and trying to enforce discrimination laws. These are complaint or referral driven. So an employee who's terminated or not hired or is asked to do a new I-9 when he or she thinks she shouldn't, can call DOJ and file a complaint, and they will investigate it. We also can get referrals from other government agencies, and this is very common from E-Verify, and it's a little ridiculous that it happens this way, but it is a reality. For whatever reason, permanent residents typically provide their green cards for the I-9 process. It does not mean that an employer is requiring them to do so. The E-Verify reports will show this happening. They will show that you're getting green cards for all of your green card holders. And then they will refer that to DOJ to verify whether or not you're doing that intentionally. And so they'll come in, DOJ will come in and look at your processes to make sure that you're not mandating that permanent residents provide green cards. So that's very common. It's one of the most common ones we see in terms of DOJ inquiries. The process, they start out by interviewing witnesses, and we, it may be really informal in the beginning. They'll call us up, they'll want to talk to certain people, and it may be resolved at that point. After the interviews, typically in the cases I've dealt with, we're able to resolve at that point. If there's documents that need to be obtained, we may go through discovery. If there are violations, then typically again, there's going to be some fines that will be negotiated into a settlement. And additionally, in addition to monetary fines, you may have to do certain training, certain postings. They may be monitored by the government for a while for compliance. And then the individual also still has the private right of action to sue, kind of like an EEOC situation. They can sue after they've been determined that they had a violation. The penalties that you can get for those types of violations include Title VII damages, attorney's fees and costs, civil monetary penalties, having to put up notices, having to correct information that you've posted or in someone's file, and going through a lot of education regarding the verification and discrimination laws to ensure that you're not doing anything incorrect. So the DOJ is a lot less common of an issue, but whenever we talk about making sure that our I-9 practices are rigorous and solid, we always have to put the stop on that to ensure that our employers are not going too far and end up with a different type of violation. So how do we navigate this? And so there are a lot of steps that employers can take to ensure that they're not having issues with ICE or DOJ. And it really starts with your I-9 processes. But actually, before I get into this, Anna, were there any questions regarding the last section?
Yes, I have one question.
Okay, thank you.
If an employee is rehired for a summer position each summer, do you re-verify every year or do a new form since there is only one space for re-verification in Section 3?
So again, there's also an element here whether or not it could be seasonal. That sounds like what they're suggesting is it's not a seasonal position. So again, the rehire rule, the I-9 form must still be valid, and it must meet the time period. If you've already used the rehire section, then you have two options. You can do a new I-9 attached with just the rehire section, or you can do another complete new I-9. As long as it's not a seasonal person, you're allowed to complete a new I-9 in any rehire situation.
Thanks, David.
Thank you. So employers need to set up procedures to deal with ICE raids. What happens when ICE shows up with a warrant? Who gets contacted? Who needs to know? Make sure that anyone who would have that first contact is aware of those procedures. Designate specific individuals to be involved in any sort of process. Prepare employees for what would happen in this type of situation. Obviously, there are certain businesses where it wouldn't make a whole lot of sense for employers to talk about raids with their employees, but we do have a lot of businesses where ICE shows up, employees are gone, regardless of whether or not they're documented. We've seen employees who are just too afraid to come back to work, regardless of their immigration status. In fact, we had a company where we had several DACA workers. ICE had arrested 2 individuals in the parking lot, and they did not want to come back to work because they were terrified. So if you have workers who are kind of in that situation, you want to explain to them, their rights and what to do if that happens. And then obviously be prepared to address media. Years ago, there was a bakery that had been shut down, had their doors chained, and there was a lot of media attention. And I started getting phone calls from other similar business saying, I cannot have that happen to me. The media coverage of what happens can be very damning for a company as well. So having all that prepared and ready to deal with is very helpful. Also, I-9s. You know, you have to be ready to have your I-9s inspected. You need to make sure that they're in compliance, they're up to date. Regular internal audits are helpful, and also remedying errors. Again, it helps just to find mistakes and to correct the procedures that way, but it also shows good faith. And it's also very important to have an outside party, independent, conduct an I-9 audit as well. A couple reasons is bringing in the expertise that may not be in-house, and two, to ensure that there are not any bad actors within the company who would intentionally hide I-9 issues. How often those need to be conducted is largely a function of turnover. If you hire one person every 2 years, you don't need to do this very often, but if you have a high turnover rate and you're hiring 100 people every year, these are situations where you really want to be careful with that. So just kind of a little bit more on what we're supposed to do with I-9s. Again, November 6, 1986 is the date it took effect. Any employee after that date, hired after that date, must have one. Section 1 must be completed by the employee no later than the start date of employment. There's a lot of confusion sometimes with this as well, because we use the terms hire date, start date, and so forth a bit interchangeably. We are talking about, for I-9 purposes, the day the individual actually begins employment. You could hire someone today who's going to start in January. January's that Section 1 date comes into play. They must be completed by the employer by the end of the 3rd business day after the employee starts work. That was historically interpreted to be the 3rd day, so Monday, Tuesday, Wednesday, for example. When E-Verify came out, they affirmatively stated that it's 3rd day after the 1st day, so basically the 4th day. So if you have a normal Monday through Friday business, then you hire someone on Monday, you start on Monday, Thursday is your day to complete the Section 2 and I-9. You also may complete the form prior to the start date, but only after offer of employment and acceptance. So again, the example, I could hire someone today, he or she accepts the job, but isn't starting until January, we still can do the I-9 now. We can complete the entire thing, and that's perfectly fine. They're really picky these days about ensuring that you put NA or none in all, to ensure that all the fields are complete. If there's something that doesn't go there or is not applicable, they want you to so mark. Make sure you're using the correct version of the form. I won't leave this up there, but it's a SMART version, which means that it helps you as you put the correct information in with drop-down menus. One thing to note about the current version, there is a Spanish language version. There always has been a Spanish language version, but it is only valid in Puerto Rico. You can use it for the purposes of allowing an individual to reference it, but it must be completed on an English language I-9 unless you are in Puerto Rico. And with the 2 pages now, I just mentioned a common error we see. The top of the 2nd page requires you to put in the individual's name and immigration status, and to ensure that the pages stay together. Very often that information is neglected on the 2nd page. Talked earlier about a blatantly false document and what an employer's obligations are with respect to a blatantly false document. They don't expect us to be CSI and looking at the documents and determining whether or not it's legitimate. They expect us to be reasonable. So, if the person comes in and has a document that their picture is not them, for example, or their names are different in different sections, those are situations where, it's going to be something obvious in the documentation that would make you not want to accept it. We're not looking to see if there's some kind of oddity that only someone who's an expert on those documents would be able to identify. So this is a little fun thing there. You know, this is probably an example of something that looks fairly legitimate, but because of some of the silliness to it, would be considered to be not reasonable to accept that. So it's always a question of the content of the document and the nature of the document. You know, they say it's a reasonable person standard. So, you know, just use good judgment and don't be overly aggressive, because then the DOJ will show up for that as well. A couple of notes on Social Security cards. There are at least 50 valid versions of the Social Security card, so they look a lot different depending on where they're from. They are almost impossible for even people who look at these every day to know if they're fake or not, unless there's just something really bad about it. There are a lot of Social Security cards as well that have certain restrictions on them. So it says something such as not valid for employment without INS authorization or DHS authorization. Just note that that means that is not a valid listee document, because it doesn't indicate work eligibility. They have to have some other document to indicate work eligibility. Like we mentioned earlier, do not re-verify expired U.S. passports, passport cards, permanent resident cards, and List B identity documents. That exact date, again, was April 3rd, 2009, when that took effect. Don't accept Social Security cards with one of those annotations for List C. And then avoiding unfair document practices. So do not require specific documents or combination of documents for anyone, and certainly not based on their heritage or perceived heritage or citizenship. Do not require more documents for certain individuals. Again, do not refuse to accept documents that reasonably appear to be genuine. And it's always the employee's choice of what documents he or she wants to provide. And question comes up from time to time: what if the employee gives you too many documents? The actual best practice is to give those back to the employee and say, here's the list, just give me what you want to use. You know, if a person were to give you a green card, a driver's license, a Social Security card, you know, you can be flexible as to which of those things you're going to choose. You could do the green card or the other two, and you're not really going to have any issue. But again, the best practice is to let the employee choose. Mentioned the retention requirements. It's at least 3 years from the date of hire, or at least 1 year from the date of termination, whichever is later. Once you've met the retention requirements, you can purge or shred the forms. We used to recommend it because there was a potential for liability, even though you weren't required to have them. The court cases come out in recent years that states that you cannot be held liable for I-9s you're not required to have. So this is just really a question of keeping your records clean now versus the liability. Photocopy rule. This is all really common. Do we copy or do we not copy? Certain states require you to keep copies. Certain documents have to be kept copied before you verify. The question is to be consistent. If you're using E-Verify, I recommend that you keep all documents in order to ensure consistency, but it's not necessarily required. And so if you don't use E-Verify, or you don't have a state law involved, you can choose documents or no documents, but you have to be consistent. If you decide to change that policy, you have to have a point in time where that policy changes. You know, even if you have copies of documents, you can still be fined if there are issues with the I-9, but sometimes having those documents will help remedy or mediate the violation. And during self-audits, the photocopies can sometimes be used to help correct errors. So just surviving the ice age in a nutshell. Make sure we're not assigning untrained personnel to deal with any of these issues. Know where your I-9 records are. Find out about any no-match history. And create I-9 procedures for uniformity. Respond to any risks or complaints that come up. Arrange for I-9 audits by external party. Again, hire a lot of new hires every year annually, probably, but if not, you can do that less often. ensure you're doing internal audits, and make sure you coordinate on any requests from ICE. Lastly, we do recommend using E-Verify. Despite the issue with the DOJ referrals, it gives you some level of protection against any type of knowing hire violations. If you use E-Verify and it says the person's authorized, unless you've blatantly done something unlawful, you're not going to be liable for the fact that that person is not in fact eligible to work. So that is all we have, and I believe we're right at our end time, but hopefully we have some, we are able to take a few questions if there are any at this point.
We do have a couple questions.
Okay.
It has been discovered to copy both sides of documents from items A, B, and C. This is not something we are doing. How should this be corrected?
So to follow, basically they're saying they have not been copying both sides, and they're asking how to correct that going forward.
Yes.
So really with that situation, it's to just start copying them correctly. You don't really have any basis to go back and request the documents again to correct them. And frankly, I've never actually seen ICE have any issue with the fact that there is only a front copy of the front. It's always possible that someone could take issue, but in all of the ICE investigations I've dealt with, that's never been something that they've raised.
Right. Our second question is, if an employer uses employee onboarding software that has the employee complete their portion of the I-9, can a third party complete the employer portion of the I-9 if they can view the ID documents electronically?
So that's actually a very good question, because it's been a problem for a lot of employers, is what to do if the employee is not where you are. And this can be the case with whether it's electronic software or not. That's a little more complicated if it is electronic. But as an employer, you can designate anyone you want to act as your agent for the purposes of I-9 completion. I've actually seen people use like a person's parent. I don't recommend that. Typically, what you see is notary or some other type of business service. If you're using a notary, the notary is acting as your agent. The notary is not notarizing the documents. And so in that situation, you've basically just authorized the notary to complete Section 2 on your behalf. But of course, you're liable for any errors. Where that becomes more difficult in electronic softwares, depending on the software, you have to authorize certain people to have access to that software. So it really is going to be dependent on how that's done. But as a general rule, you can allow anyone to complete it on your behalf. You're just liable for the errors.
Okay, our third question is, what if you have employees that have filled out the I-9 in Spanish but not in PR?
So there's two different kind of potential scenarios here. If you are in the process of completing the I-9, you just started and they've completed on the wrong form, the best practice at that point is to just give them a new form and start fresh. If you discover after the fact that a Spanish language form was used, then it is not a valid form, and you would basically have to just redo the I-9, as if the person had never done one. The start date obviously would still be the original start date, but everything else would be done as of today, and then you would keep the Spanish language I-9 attached to the new I-9.
Okay, our next question is, I just started with a new company. We cannot seem to locate I-9 forms for employees. We're not sure where the previous HR staff kept them. What do we do now?
So this is actually a very serious potential issue, and kind of how you handle it is a bit sensitive, especially depending on where your business is, whether or not there's a union and so forth. If you do not have I-9s on file, you are in violation of federal law, just period. If you have I-9s on file, you don't necessarily have a legitimate legal basis to go back and request that an employee do an I-9. So first of all, I just want to just kind of double check to state that we definitely do not have these anywhere. We are not in compliance. In order for us to be in compliance, we must do these new I-9s, and you take that to the employees. At that point, if an employee doesn't cooperate with that process, number one, that's a red flag. But number two, it should be grounds for termination in most situations because the employee is not cooperating with something you're required to do for federal law. Where it gets stickier is where there are unions involved, or if you're in California, where there's all kinds of laws that prevent you from terminating someone. In some situations, you may have to provide someone unpaid leave until they resolve the issue, for example. But the general rule is that you just need to have those I-9s on file, even if it means doing new ones. Now, as I mentioned earlier, in the same case as the Spanish language form situation, the I-9 will still have the correct start date, even though it's completed 5, 10 years later, whenever. The start date is still going to be the original start date, and everything else is going to be today's date. These I-9s will be deemed late regardless because you don't have contemporary I-9s with the hire, but you are bringing yourself into compliance with the law otherwise. Okay.
David, we do have about 10 more questions. Did you want to answer those now, or did you want people to go ahead and email those to you?
I think with that number of questions, we probably just ensure everybody gets good answers in a reasonable amount of time. I think email might be more effective for that, and I'm certainly happy to answer all of those. And I don't know if you could post the responses. I don't know how you would want to do that necessarily, but I'm happy to have them posted as well once I've answered them all.
We could do that. So if everyone can take a look at the lower left-hand screen, David's email is featured. It's djones@fisherphillips.com. So you can send him emails if your question was not answered. And here is David's email again. If you just have any questions, didn't get your question answered, you can go ahead and email him. And my email is up there, anna@hrsimple.com, if you had any additional questions about the webinar. Thank you everyone for being here, and we'll be back next month with a webinar on Generation Z entering the workforce. Everyone have a great day out there. Thanks again.